Okay, we're live. Good day, everyone, and thank you for joining us today for the second panel of Columbia Arbitration Day. We have with us amazing speakers, so please take advantage of this, put some questions on the YouTube chat. But before we introduce our moderators, some quick announcements. For those interested in CLE credits, you are aware CAD grants a total of 6 credits. This panel in particular will give you 1.5 credit for skills. So to be granted this credit, please, you will have to submit the attendance form and the evaluation form, which are available to download at our website. And you will have to submit it to the email addresses that are mentioned on the website. Please record all attendance verification codes displayed during the program. You will need them to fill the attendance form. And review CAT's website to see the instructions regarding CLE credits. We have also uploaded some reading materials related to the topic of this panel. On the second announcement, as you can see, because of the pandemic, unfortunately, CAT has to be held online this year. On the bright side, this allowed us to waive the registration fee and make CAT 2022 free of charge. That said, in light of the current situation in Ukraine and of the many conflicts that are still raging worldwide, we would like to invite all participants to make a donation to a humanitarian organization of their choice. Thank you for your attention. Mateo, you have now the honor of introducing our moderator.
Thank you very much, Luis, for that useful information. I now have the pleasure of introducing our moderator, Mrs. Rahim Moloo. Rahim is a partner at the International Arbitration Group of Gibson Dunn, based here in New York, and is also our very own arbitration adjunct professor at Columbia Law School. He obtained his Bachelor of Laws degree from the University of British Columbia and his LLM degree from New York University. Rahim will be introducing and moderating panel 2, which relates to reforms in international arbitration through the use of artificial intelligence. We are proud and happy to have him with us today. Dear Rahim, the floor is yours.
Thank you, Mateo. Appreciate it. And Mateo is one of my very dear students. So always a pleasure to be introduced by a student. And I have the pleasure of introducing our panelists today. We have Abby Cohen-Smutny, who is Global Head of White & Cases International Arbitration Practice and a partner based in the Washington, D.C. office. And she also gave me my first job in international arbitration many, many years ago. We have Tunde Ogunseitan, who is an independent arbitrator, and many of you may know him from his years at the ICC. He was the head of all the common law jurisdictions for a number of years with the International Court of Arbitration. We then have a third panelist who you don't see on the screen at the moment. He's having some technical difficulties, but hopefully he'll be able to join us shortly. Tom Snyder, who is a partner and the head of the arbitration group at Tamimi & Co. in Dubai. So with that, we will turn to our topic that we'll be speaking about today, and we hope to have a robust conversation and welcome any audience questions that you all might have as we discuss the topic, and we'll try and answer them real time. The topic that we'll be discussing is reforming international arbitration through the use of artificial intelligence. So the use of AI in IA. And the first thing that a lot of folks ask is, well, how can one use artificial intelligence in international arbitration? And what you realize, and hopefully you will realize over the course of this conversation, is it's already being done in many different ways. And there are ways in which it's being investigated. The use of it is being investigated in international arbitration. So we'll take you through starting with some of the things that are already being done, And as the conversation progresses, we'll get into some of the more futuristic potential uses of artificial intelligence in international arbitration. So the first topic we'd like to address is the use of artificial intelligence with respect to identifying relevant evidence. So Abby, let's start with you. And there's Tom. Glad and it looks like you can hear us, which was the issue we were having. So Tom, just to confirm, you can hear us and we can hear you.
I can hear you. Can you hear me?
Great, we can.
Great, thanks.
How appropriate that we have a technological glitch on a panel that's talking about the use of various forms of technology in international arbitration. But the first question, Abby, for you, maybe you can just give sort of an overview of how you in your practice, or you've seen others use artificial intelligence to help identify relevant evidence in an arbitration.
Thank you, Rahim. And it's let me just repeat, it's my pleasure to be here. So before we talk about evidence and how artificial intelligence can help us to identify evidence, perhaps we should just clarify what we mean by artificial intelligence. And perhaps as we discuss each of these topics that we're going to talk about, we'll have, we can talk about it from different perspectives, and maybe the understandings are not consistent. I mean, I think everyone is familiar nowadays with the concept of a database, and information can be stored on a database, and you can do term searches to identify documents on a database. I don't know that we would call that artificial intelligence, though. Artificial intelligence, and maybe there are a lot of different definitions, but I think maybe one basic definition is that you have a large database of information that you then program perhaps with an algorithm how to search that information, and then the algorithm or software, whatever we want to call that, learns over time how to be more precise or more useful. I think that's what we mean when we think of artificial intelligence. It's not my experience that artificial intelligence, so defined, is really currently being used to identify relevant evidence. But let's talk a little bit about what is being done, some of the challenges, and maybe we'll see over time, and maybe not so long from now, real artificial intelligence on evidence. I mean, I think, again, everyone is familiar, and it's the case that it's quite common that documents or information particularly relevant or possibly relevant to a case is stored on a database, or software is used to search, maybe term search on a certain laptop or other database, usually term searches. Usually we're looking for certain words. I think over time we're seeing that software is becoming capable of looking for certain phrases. So I think the capacity to search for dates, for phrases, for names, this is definitely continuing to improve, and this is useful. I can say that in our practice, it's quite common that we use databases to store evidence. The downsides, I'll say, or where we still, I think, struggle, or one needs to bear in mind the role of the humans here, is that somebody often needs to code documentation, and how you code the documentation is very important. We're not at the stage that really where software can reliably scan and identify accurately certain terms. We wish it were, and maybe in some simple cases it works that way. But in reality, we find we're dealing with different languages. Of course, then your software has to be sophisticated enough to identify different languages. Sometimes there is marginalia on documents that becomes very relevant. Sometimes the context in which the document exists becomes really very relevant. Sometimes quality copies are really very poor. That's, an issue. But I guess there's no question that computers are already helping us a great deal managing large groups of documents, or large databases of documents. I'll say one other thing and then turn to others to comment on this subject. And that is, at least right now, databases and the use of databases is still a large expense item. And one can imagine that there may be a time, and over time, maybe it saves some money. But I can say from a practical point of view, the cost involved in setting up and maintaining and using a database is still highly relevant in practice, and it's not always useful. So maybe let me turn to others to comment on some of the things I've said, and then we can go to keep it moving. There are a lot of topics to address.
Thanks, Abby. And either Tunde or Tom, have either of you, so at least in my practice, I know we have used some predictive coding tools, for example. So as Abby said, humans will code the first 100 of, let's say, 10,000 documents. And then, you know, the tools used learn what seems to be a relevant document. Maybe some words are appearing more than others, and they start to spit out more relevant documents, or at least ones that the AI identifies as being more relevant. Have you used those kinds of tools in your practice? Tom, I see you nodding.
Yeah, no, I have to some degree, and I think I'll probably sound like a parrot by the time the panel is over, but I think it's important to bear in mind that an AI program is only going to be as effective as the data that goes into it, and it needs a lot of data. It feeds on the data, it looks for relationships within the data, relationships that maybe human beings can't detect easily. And the more data you're able to put into the system, the better it works. So I think that's why when you're talking about evidence and document production, this is one area in international arbitration in particular where I think AI has started to play a role and will play a greater role over time, especially in large cases where you have tens of thousands or hundreds of thousands of documents that are at issue. And you can see how this could develop in various stages. It's sort of the beginning of the case. Your client might put the documents into the system that they have. This will probably be a bit rudimentary at first, but you know the predictive coding and the processes can be applied to that. When you get the documentation from the other side, you can add that as well. Documentation from document production, witness statements, and so on. And so the more data that the program has to deal with throughout the course of the arbitration, the more refined and helpful that will be. But I think this really is one area where we're starting to see some practical impact of AI, and I think we'll see quite a bit more in the future.
Tunde, what about you? Have you seen it or used it?
I used some sort of predictive algorithm when I did litigation prior to our arbitration. And as arbitration begins to look more and more like litigation these days, we're employing the same tools to sift through documents. But that's from a cost perspective. People want the certainty of doing the work of an army of paralegals by using technology to drive down costs. But the problem, of course, with that is what the two previous speakers have identified, which is that it depends on the amount of data you put into it in the first place. As these technology become more commonplace and cheaper because of their relative use, and as they learn, we will see a significant impact of their use, because they will, I believe they will drive the cost down in international arbitration.
Thanks for that. So it does seem like at least it's coming in to play a little bit, at least in my own experience. I'm not sure it was much better than humans doing the work, but I think you're right, Tunde, that there may be a cost and efficiency from a timing perspective. Computers can do this a lot faster, at least, than humans can, identifying certain key terms, and and the predictive coding tools tend to be faster. I don't know that the cost has gone down all that much quite yet, but but I think we'll eventually get there. So Abby, let me turn back to you. In terms of researching the law, that's something that a lot of folks have written about, that and I'm not sure to what extent it's being used in your practice or others that you've seen. Is AI a tool that you see now or in the future being used, or can be helpful in identifying and researching the relevant case law, for example?
So I think, again, we're all familiar with Lexis and Westlaw. In other words, there are already significant, and there are numerous others, there are significant databases of legal materials that people use for term searching. And in fact, phrases and so on are becoming easier to search. So the search tools that are available and the extent of the databases available is increasing, and these databases are becoming better. Are they at the point where we can call them artificial intelligence, in the sense that the software is doing more than searching for terms or phrases that you put in? Is it learning, and is it predicting? I think we know that there are examples of AI being used in some contexts. I think there have been examples in predicting the results of court cases or court decisions with certain judges, predicting the results of the European Court of Human Rights. I think what's interesting to consider here is that what's necessary in order to do real AI searching or predict, you need to have a database of relevant information that is, material and significant enough. Almost all commercial arbitration, and now I'm not talking about investment treaty arbitration, but commercial arbitration, most of the international arbitration that happens today, it's not public. There are no public databases of arbitration decisions, or at least they're not at the level that one might want for real sorts of, predictive analytics. I was interested to see there's a company called Arbitrators. I'm sure it's not the only one. There are companies out there trying to provide analytical predictions using databases of, decisions to help parties. And of course, we can all talk about what we would like to see would like to see happen. Wouldn't it be? And to some degree, these things are being used, but I feel like they're still very young as far as the industry is concerned. There definitely are some, maybe more in investment treaty arbitration, where there's a universe of public information from which already certain things can be predicted, perhaps. But I mean, these things also, we should bear in mind, they're limited. I mean, for simple cases, where the fact patterns are simple, where the results are maybe binary, you can imagine it's easier to use real AI to help predict. The more nuanced things become, the more challenging, no doubt. So, I think, in short, are we using AI right now to do legal research? I would say not that much, but there's a lot of talk about it. And so I think, I expect maybe 5 years, the conversation might be a little different. Maybe let me let others comment on this, so we can come back, because there are other aspects to it. One other thing, though, that occurs to me in terms of legal research, an example of what I mean, of what's challenging and why maybe a simple pattern is easier to predict. In our law changes over time, the context of certain rules, how do you weigh the different evidence? What kinds of phrases is the software looking for? The software would have to be pretty darn sophisticated, and no doubt it's getting there, but it would have to be pretty darn sophisticated in order to really be effectively predictive, I would say, over time. But but let me let others comment on it. It's interesting.
Abe, if I chime in, I think the difference is between synthesis and certainty. Can we synthesize what a human can do and the thought processes that a human can follow with the current technology we have to even drive the research and the certainty of the outcome of using automated systems? And how do we balance the synthesis versus certainty question? That's what I see. And now what we describe as AI are algorithm functions rather than pure decision making, which the current systems can't do. Yes, we can program an AI to win at Go or chess, but I dare say from the US perspective, it won't pass driver's ed, so to speak. And in that, the amount of research, the way research is directed, the leaps we take in research are not proper. They're not properly sort of taken into account by the current AI system that we have.
Tom, thoughts?
Yeah, I think this is really interesting. I think Abby and Tunde have raised a lot of good points. In my mind, this issue to some extent goes to sort of the crux of what AI can and cannot do for us in international arbitration. And I heard Abby use the phrase, predictive tool or several times. And to me, that's really how AI is going to come into play in international arbitration. It's going to be a tool. It's not going to run the show entirely. And B, I think its greatest utility is in terms of prediction. I think Yogi Berra once said, prediction is tough, especially when it's about the future. And that's true here. But I think in the two topics we've covered so far, that's where AI can really be of the most use. Analyzing the evidence, helping us with legal research, and helping us predict what the likely outcome may be. It's not going to be foolproof, but I think it can help lawyers, it can help clients. I think players such as third-party funders can use it for these sorts of tasks in the future. I think arbitral tribunals, to some extent, we'll talk more about that later, I think, but I think there may be some pitfalls there. But at the same time, and I'm going to go right back to the data issue, and Abby touched on this, but, there are a lot of limitations in how effective AI can be based on the data we have for the legal research. Abby mentioned the U.S., the study relating to U.S. Supreme Court decisions. I think in that study, they went all the way back to John Marshall era, 1816 or something like that. I think there were 28,000 cases that they collected, 240,000 individual votes, and the accuracy in that test was about 70%. Now, 70% sounds pretty good, but if you've got an AI system that has access to 28,000 court decisions going back pretty much the entire history of the U.S. Supreme Court, I think one could say I'd expect a 90 to 95% accuracy rate. So I think that highlights some of the challenges we face. I think another point that Abby touched upon that's very important is changes in policy. There is some, when we have a change in policy or a change in the legal doctrine, it does take some time for the data to catch up with that. And the results you get the day before the change in policy will be very different from the results you get the day after.
Yeah, no, those are all really good points. And I think one of the other things that differentiates international arbitration, at least some areas of it, and litigation is, when you have 70% accuracy in a system where the court cases you're reviewing have precedential value, it's also different than when those cases don't have precedential value, and there isn't necessarily consistency in any event between two tribunals looking at the same fact pattern. And so, the concept of not having stare decisis makes it, whether it's AI or otherwise, just more difficult to predict things, which is a separate topic in and of itself. But one of the other challenges in using AI for this purpose. That's not to say, again, though, that these tools, it won't be used as a tool, but just to echo some of the comments that you all have been making. So along this sort of same discussion of using AI to identify or try and predict the outcome of certain cases or to research the law, perhaps it is, if we narrow the universe of what we're trying to do, it might be more helpful. And one of those things that we all spend a lot of time doing and have associates researching is selecting arbitrators. How might an arbitrator decide a particular case? There are a lot of databases that are being put together about different arbitrators and what their decisions have been and things like that. But to what extent do you see potentially AI being used as a tool to, I suspect, I'm going to come to you, Tom, and I suspect you're going to tell me something about, it depends on how much data we have about those arbitrators, which I completely agree with, but how useful can AI be in the context of helping identify an arbitrator for a party?
Yeah, I think, look, I'm much more bullish on evidence and legal research, and I'm more bearish on this issue. And I know that's not what everybody wants to hear, but let me try to explain why. And to some extent, Rahim, you've already touched on it. It does go back to the data. And, there are different ways to slice data. You need a breadth of data, but you also need a depth of data. And I think if we sort of take a step back and we look at where we are in terms of how we approach the selection of arbitrators, and where we want to be by using AI to assist us in that process, there's a pretty substantial gap, I would say. I think when it comes to selecting arbitrators, you could probably argue that we're still driving Ladas from the 1960s, and AI would be driving a Lamborghini. And what do I mean by that? I mean, different people approach it in different ways, but as you alluded to, Rahim, selecting arbitrators often involves, a lawyer sitting down and thinking about, well, who have I used before? Who do I know that might be good for this case? You might go down the hall, talk to your colleagues about it. You might call up some people, get their input. And then a lot of times you'll make a long list. You'll do a little bit of research on the arbitrators, make your short list, and make the call. I think there's so much more we can do than that approach. And I think there's so much more that technology can do to assist us in that. These databases and these analytical tools that you referred to are important. The reason I'm more bearish on artificial intelligence helping us in this regard is very much the data issue. It I think is going to be very difficult to collect in one place the amount of data that you need on arbitrators in order to make to use AI to make these decisions. Now, one challenge we face in this regard, Abby has already alluded to in the context of legal research, but of course it applies to the selection of arbitrators as well, and that is the confidentiality issue, at least in international commercial arbitration. We just don't have the size of the database we need in order to assess prior awards issued by arbitrators to see how much help they can be in future cases. There are initiatives underway to do this. For example, the ICC, and Tunde will correct me if I'm wrong on this, but the ICC has now made a default position, I think, where the awards will be public unless the parties opt out of that. If I'm not mistaken, a lot of parties have indicated that they want the awards to remain confidential, and not a lot of awards are being publicized through the ICC. There are other initiatives in more of the private sector. Arbitrator intelligence, for example, is trying to collect and aggregate non-confidential information from awards. But I think we're a long way off from getting the sort of size of database that we need in order to use AI. We can use other forms of technology, data analytics and the like, but to effectively be able to use AI to mine that data and help us make decisions. The other aspect of this too is that if you're looking at potential arbitrator A, potential arbitrator B, and potential arbitrator C, each one of them may only have a handful of decisions where they've decided on a particular issue. Let's say you're going to have a particular jurisdictional issue in your case. You want to select an arbitrator that's going to help you with, share your view of where we ought to come out on that issue. You don't need AI to sort of run these in-depth analyses. You can use data analytics and help you in that regard. And I just hearken back one more time to the U.S. Supreme Court study that Abby mentioned and I talked about a few minutes ago. There's only 9 justices on the Supreme Court at any given time. You've got sort of a finite number of decision makers producing the cases that you're going to analyze with the AI system. In international commercial arbitration and to some extent international investment arbitration, you have a much wider group of players, and it's hard to get that depth of data in relation to each one of those players to make the AI system work effectively. But let me stop there and see if my colleagues want to jump in on that.
I take a slightly different view in the sense that the data already exists in the institutions. And to the extent that the institutions see everything, they understand the issues, especially institutions who participate in scrutiny and see the awards in its entirety, then that data exists. Now, Tom, I will take what you said about the depth of data, and that depth exists in the institution. The problem I see is when the parties start looking for what I call unicorns. We used to call them unicorns with wings, where they have specified so many requirements for their arbitrators where you can't find those individual things in one arbitrator, but what the computer will spit back at you, even if you included what is effectively 80 years of data that the ICC has, for example, on arbitrators and who's doing what at the highest level. And it goes back to my synthesis issue in the sense that will the computer be able to identify what the parties want, given that the parties are sometimes very difficult when they're looking for arbitrators and they request things that maybe no one has. So the question is what we want to use the AI for rather than what can it do. I think the data exists on some level in the institutions that take a real hands-on approach in arbitration. They know what the arbitrators are deciding. They know the issues that the arbitrators are deciding. So you can start using that data to build a system. And I don't think there's anything bad with institutions combining their data to create a universal tool for everybody to use, it will not be AI in the sense, because you will not be able to synthesize what parties do, and it removes the bias out of it as well, because you plug in your requirements, even down to the substantial issues which the institutions have, and that system will bring out at least the potential candidates and narrow it down for the parties.
Abby, let's turn to you. I have some
Yeah,
comments too.
Look, yeah, I mean, one topic, talk about a barrier to entry, right? I mean, you know, I mean, maybe that's clear enough. I think that's a big issue, a barrier to entry. That, you know, look, that being said, what do we all do when we are working with our clients to try to identify an arbitrator that we feel comfortable and appropriate? We do ourselves try very hard to predict, to the extent that we can, whether a given arbitrator is going to be at least sympathetic. Of course, every client wants to win. So every party wants to win. You want to find an arbitrator that you believe is likely to decide the issues, you know, in your way. We also know that there are a lot of data analytics, predictive tools out there. I think we've all heard about, or maybe even encountered, some pretty, I think, creepy technology where there are, you know, big tech companies that can predict how, you know, a given individual votes, you know, in an election, depending upon, I don't know, you know, which sweater they buy or what car they buy. I mean, it calls into question, you know, what would you look at to consider an arbitrator and to predict his or her likely opinion on an issue? One can't deny that there's a lot, folks are working very hard on this and are trying, whether the data is perfect or imperfect, they're trying to use information that's out there and to predict whether this one or that one is going to be sympathetic to the claim. And inevitably, these tools are going to become used more and more because people like them and feel like it's giving them, you know, some, I mean, maybe too much emphasis is placed on them. I think we would all feel irritated to know that there's a computer watching you and is going to predict how you're going to feel and decide about something. I think we all instinctively would think, no, you can't predict me. But maybe we are, all of us, somewhat predictable. Anyway, I find this all a bit creepy. Honestly, but it's there. And I think we need to recognize its strengths and weaknesses and do our best to ensure that it does not prevent us from getting the sorts of results we want, including keeping arbitration inclusive, effective, and talk about bias. I mean, if we keep going to the same people who have great, you know, data, we're going to have their biases. So it's a complicated subject, I think. But I think we can't be naive. These tools are out there. They are being used, and they are impacting who is being selected in what context.
Yeah, so many interesting points that you all raised. But I think one question I have, and this is, you know, and I mean, this question comes up in the use of AI in all sorts of contexts, is, and to your point, perhaps, Abby, of this being all a little creepy, is it always a good thing, right? Do we want AI to help us choose arbitrators? Because, I mean, one of the things that we all think about when we, I know that there's an increasing push, including in commercial arbitration, towards transparency, including with the ICC's decision to, you know, to agree to publish awards unless the parties don't want them published. Does it change behavior of arbitrators if they know that they're being watched and they are all of a sudden, you know, not just deciding perhaps this one case that's in front of them for the parties that have appointed them, but that decision is going to then impact the way other parties view what they do? I mean, in the judicial context, obviously, when you have the Supreme Court, it is about more than perhaps just the case that's in front of them. There's a policy element to it. Do arbitrators all of a sudden perceive their role differently, or are they influenced in some way that we perhaps don't want them to be influenced if they feel that their decisions, even in the commercial arbitration context, are being used to decide whether or not they ought to be appointed in other cases? I mean, that's probably already happening to a certain extent in investor-state arbitration, certainly. But not as much in the commercial arbitration context. And there are other reasons for transparency in the investor-state context that don't necessarily always, although sometimes they do, play in the commercial arbitration context. So I guess in short, the question is, do we think it's a good, do we want this tool out there? If it could exist even, to have AI help us identify how an arbitrator might decide a dispute.
Let me just say what I was saying before, which is this is out there. People are going to use and already are using all the information they can find to predict how someone is going to decide things. So I do think we have to recognize that it's there. And maybe all of us just need to be educated, well educated on the limits of this. If you have two cases in an arbitrator in a row that have certain similarities, does that necessarily mean that the third case, is going to be the same? I guess that's just my way of saying these things are nuanced, or they ought to be nuanced. But I do think that whether we like it or not, and they're there. I think it's for us to educate ourselves on the limits of these types of technologies, and then use the tool and understand it's just a tool and it's imperfect.
Yeah. And perhaps just building on my question a little bit. For example, and Tunde, I don't know what you feel about this. You're right to say theoretically it's possible, but I would be uncomfortable with institutions, for example, that have a universe of arbitral awards, using that information to then create a tool that might help a party decide, who to pick based on their substantive decision making in those, even though the arbitral awards wouldn't be public. For the institution to create a tool that would allow arbitrators, or parties to sort of use that tool in that way makes me, I don't know if it's how others feel, but uncomfortable.
You feel creepy. Like
Creepy.
I think the watch world here is creepy. The question is, do we want the tool or not? And to an extent, arbitrators' behavior has already been modified by the decisions they make. You've already mentioned that certain arbitrators will not write publicly about certain issues, especially those that do investment arbitration, because they will be perceived to have prejudged the situation once they form an opinion on it. Now, I say it's possible. You asked what is possible, and I gave you what is possible. Right. I didn't say it was right to do it. That's two different things. If you ask me what is possible, I'm like, this is possible. But is it right? That will depend on whether somebody will find a way to create that database and give the parties access to it, and whether people will use it or not. It's interesting from a counsel perspective how it's been indicated by somebody saying, you try and find someone who is sympathetic to your point of view, not that, as we say, independence and impartiality is where we stop at. Is he independent? Is he impartial? We don't really want to know how he thinks. We just want to know that he will give us a fair shake. But we go further than that, don't we? We want to know how he views questions of facts and how he actually thinks on some issues, on questions of law. It will depend on which jurisdiction he's coming from. And these are fundamental jurisprudential questions that we are asking we want our arbitrators to take, but we want to be able to predict them when we select them. So we want this option, but at the same time, we don't want it. The question is it a sword or a shield? Yeah, how do you want to use it? Do you want somebody else to use that algorithm or that AI as a sword? But at the same time, you must also think of it that if you are the respondent and you're choosing next, you will use it as a shield. I am going to look for an arbitrator who thinks contrary to him to balance the arbitral tribunal. Now comes the chairman. How do we select the chairman? Yeah, and so yes, the data can be derived from certain sources, but how do we use the tool? Is it a sword or a shield? But we also, when we select our arbitrators, want certain built-in biases. Yeah, that's how I would describe it. Built-in biases in the way they decide questions of law and questions of fact. And the AI will emphasize that. As creepy as it sounds, that's exactly what we want, but we don't want to say that's exactly what we want.
Yeah. Tom, I'll give you the last word on this. When you're picking an arbitrator, do you want to know all of, how much do you want to know about her when you're, and I'm sure you want to know everything, but how much should how much should we know about her? Because and to Abby's point earlier, there is a real risk, I think, on the diversity of arbitrators that are out there. Already, if we are going to limit ourselves to wanting to know this information about the arbitrators, what does that do to and maybe with respect to chair people, actually it ends up being easier to pick a first timer or someone we don't have as much information about, because there's at least a perception of objectivity that isn't there with respect to someone who comes with for lack of a better term, with all this baggage. But Tom, last word to you.
Yeah, well, lots of issues here. How much do I want to know about an arbitrator? You're right. I want to know everything, but is that feasible? And do I really want to know? Sometimes at the end of the day, I mean, look, you could use AI if you really want to get carried away and you have the means to do so. There is a big set of data out there called the World Wide Web, and so you could use an AI program that analyzes, Twitter posts, Facebook postings of potential arbitrators to get a sense of, maybe you won't know how they'll stand on legal issues, but their psyche, their approach to things, and you could use this data. That's probably towards the far end of creepiness where this could go. And I'm not sure we'll go there, but I do think if these AI tools are available to assist in the selection of arbitrators, they will be used. But again, I go back to I'll end where I started. I don't think we're in a position where we need to do a tiger's leap from, calling up our friends on the phone to find out what they know about a potential arbitrator to using AI. I think if we use data analytics, if we find ways to try to increase these databases, that'll be useful. I think getting information out there about young arbitrators or new arbitrators, diverse arbitrators that maybe have only issued a few awards, but you're able to share some of the non-confidential information about those awards with others will help diversify the pool.
Lots of competing interests, barriers to entry. Like Abby said, you want information that is public, so there aren't those barriers to entry from a counsel perspective, perhaps, or parties that. On the other hand, there's barriers to entry for arbitrators, and so there's so many competing interests, and AI might help in certain circumstances, and it might hurt in others. But all things, I think Abby put it well. It's a nuanced discussion, and there are limitations to what's out there, and we just need to be thoughtful about how we use the information we have, and that information will continue to evolve, obviously. So let's turn to the issue of administering our arbitrations. Tunde, I'll turn to you first as someone who's been in that institutional role. In 10 years from now, are we going to need counsel at the ICC to help us administer institutions, or is that function going to be replaced with AI?
I think it's going to be a mix. If you look at the broad function of an involved institution, from the intake of the cases, using them as an appointing authority to making sure they ensure that the procedure is followed properly. Those systems can be automated. And to a large degree, some institutions like EBRAM in Hong Kong are trying to do it. In other instances, for example, the ICC has also tried that with the netcase system, where they have automated certain functions of submitting documents and ensuring that the parties have an automated system to collect the data, and those functions can easily be automated. What is far more difficult is ensuring follow-up, looking at what the arbitrators are doing, especially when they're new arbitrators, and correcting them when they've gone off the rails. The other way I look at it is this: no two cases are the same, and you cannot program AI to scrutinize an award, for example, because no two people write the same. There are certain elements of cultural nuances when you're reading awards and jurisprudential issues when you're scrutinizing awards, for example, that make it difficult for AI to replicate this function. Yes, your AI might be able to pick out issues of grammar, but can it follow what the Dubai court is going on unless you feed in that data? And that's a lot of data. So we're back to the data point, in the sense that humans have a way of acquiring data and just intuitively knowing what is correct when you read an award. And how will they check back with the arbitrator, for example, if they don't understand what he or she has written? That's that's a nuanced point that is not going to be easily solved even in 10 years' time. If I look at another aspect, deciding challenges, for example, there's a unique thing about deciding challenges. Sometimes it's not what the parties have accused you for in some of the challenges I've seen that makes the institution admit the challenge, but your subsequent response to the challenge that actually triggers the acceptance of the challenge. How does AI deal with this foreign inputs into it? Also, there's information sometimes that the Secretariat is aware of, because we are people and we hear things, we know things. We sometimes know that an arbitrator hasn't disclosed instinctively. We know because we've seen that incident outside. And then the dilemma becomes how to say to this arbitrator, are you sure there's not much more to say? How do we code this kind of instances into an algorithm that will make the smart decision? I think there are certain parts of institutional processes that will be automated, but there are also certain parts that will require human input going forward. And that sometimes stretch to, as we've already discussed, selecting your arbitrator, how institutions select arbitrator, the know-how of whether an award is good, an award is functional, an award is actually creative in the sense that it solves certain issues in a very unique way you've never seen before.
Yeah, interesting. And obviously the scrutiny issues that come with the ICC may not exist with other institutions. Abby, what do you think on the role of institutions and to what extent we might see AI play a role or substitute some of the roles we see counsel playing right now?
Again, maybe we wouldn't call this AI. Maybe it's more like, do we see increase in technological uses? You know, what about creating transcripts? Obviously, court reporters bring a human touch that is helpful, but, you know, maybe already they're using software. The software can continue to improve. I think we can think about more simple tasks and expect that technology is going to help with that. Translation or interpretation is a possibility, although, you know, that too, you can imagine, can be difficult. You know, does machine translation, we all see how Google Translate works. It's better than it used to be, and no doubt it'll continue to get better, but it's highly imperfect, and probably interpretation would be the same. I mean, there are circumstances in courts where, you know, courts use random generator programming to select what judge is going to be assigned to what case. That assumes that you have a pool of equally qualified individuals. Any one of them would be perfectly appropriate. And so, you know, a random generator, a computer assigning an arbitrator to, maybe it's not the same, because we just don't have an analogous pool of equally qualified persons to sit on a case. So, I mean, I think we're going to continue to see technology assisting us on the edges, and that'll become better and better. But I have a hard time seeing AI, as we understand AI, really playing more of an administrative function.
Yeah, agreed. And it does come back to what exactly is AI versus other, you know, technological tools that might be of assistance. Tom?
Yeah, no, I think that's the key point for me. I think technology will play a big role in a lot of these areas, and I think arbitral institutions can use technology much more extensively to help optimize the process and the procedure and make it easier. I'm not sure the degree to which AI is really necessary or really capable of that. You know, I think when we look at a lot of these more repetitive, mundane tasks, that's where AI is going to come into to play more. I think when we get to higher level processes and analysis, like scrutinizing awards, or, you know, I don't want to jump ahead, but writing awards, I think the role of AI is much more limited. It's arguably non-existent in many respects.
But even if I remove the scrutiny of awards, the ICC, for example, will make a determination on the proper parties in the contract, and sometimes will make a decision on the claims that are allowed under their 6.3 and 6.4 procedure. And those are actually quite substantive claims rather than decisions, rather than procedural decisions. You could see the limitation. That is not a process. That is a decision making process that will have to go to the court. And, you know, sometimes those debates are heated as to which claims can be pursued, which parties should be included and allowed to proceed with the awards. That's not a simple thing that an automative system can do, saying just check the names of the parties to the contract and then let it proceed. That's a more substantive and nuanced decision. And so we go to the decision-making process that Tom was, that somebody has to make that decision. Did this party participate in this contract through performance, and can they then be brought in right before you select your arbitrator, and the arbitrator can then make the jurisdictional decision later. So yes, on the repetitive tasks, technology will help us, but there's still substantive decisions that need to be made right at the early stages of the arbitration.
Well,
but to some degree,
sorry
if I may, to some degree, right, isn't that the beauty of technology and AI as applied to the legal industry and international arbitration specifically? What it's doing is it's essentially making these repetitive, mundane tasks more automated, and at least in theory, freeing up lawyer time to do this high-level legal analysis, debate, back and forth on these legal issues. I think the challenge for law schools and law firms is to be able to train lawyers to engage in these high-level types of legal thinking without having done those mundane tasks as much as young lawyers, that sort of rote training where you, open up the books or the papers and go through these issues in painstaking detail. You leave that to the computers and go straight to the more high-level stuff.
Abby, did you have any final thoughts on this issue?
No, I think let's move on to the next one. We still have a couple of interesting topics.
And this one we actually got a question about as well from Christina Florescu. How about using AI as arbitrators? I mean, we've kind of been dancing around this a little bit, but we've talked about mundane tasks, right? And AI can help us there. But in fact, I think it may be that just other technological tools can help us with the more mundane tasks. In some sense, AI is in the theoretical, when you talk about AI in theory, it is about those higher level, you need artificial intelligence. You need the machine to learn something and to become smart, to be able to deal with more substantive issues. And so, the most substantive issue, let's start with that, is deciding the case. Can AI, and it's interesting. We talk about, you do need certain human knowledge, and and for example, even just deciding a challenge, for example, as one example, you might know something about the arbitrator, but built into that, into human beings, is a bias, right? About, what information do they know about the arbitrator versus what they don't know. And, would artificial intelligence that can scour the web or whatever, learn more than we know about that arbitrator when deciding a challenge or disclosure issues or things like that. And the same thing ultimately can apply to making decisions. So let's, on this issue, AI as arbitrator, I think it was Tunde that offered to take the lead. So Tunde, I'll turn to you. What are your thoughts?
I'll pick up on one word you said there, bias, which is a concept of trust, actually. So before any party goes on to say that they are going to trust the AI, it's going to be a very bold decision for you to put your trust in an algorithm. And even though certain institutions have created a checklist, sort of the European Commission for Independent High-Level Expert Group has created a checklist for trustworthy AI. The issues that an AI has to pass through before we can trust it goes beyond the basic 3 levels or 3 laws of Isaac Asimov, which is on the basic level. But what is trustworthy AI? Because that's the point here. We have to be able to trust the AI to make a decision. And whether the AI can make a lawful decision, whether the AI can make an ethical decision, and whether that decision is robust. If I run through it quickly, and the first one is the main issue. Simple. Can it make a lawful decision? This appears simple, but it's not really that simple. That the AI makes a decision that complies with the applicable laws and regulation. But how then does it deal with the lacunas in that situation? Do we trust it to cover the lacunas? And that's a problem. The ethical decision is far more interesting from that. How do we get an AI to recognize a contract which has been sort of tainted by corruption? How does it independently go outside that arbitration, given that the AI itself will then be subject to what I call the contractual issue, which is it cannot look beyond what's in front of it to take issues of taint in corruption to decide issues. These are very broad issues that haven't been solved yet. And if we then go to the Harvard Berkman Klein Center for the Internet and Society, and who identified certain issues that an AI making decisions that we can trust must comply with, the list is endless. Privacy, accountability, safety, security, transparency, explainability, fairness, non-discrimination, human control, professional responsibility, and promotion of human values. I have said enough here to understand that the problems with trusting an AI to fulfill all these distinctions on a ones and zeros basis is the problem. If I might add one more thing, how does AI deal with questions of equity, for example? Which doesn't sometimes arise in arbitration. But we must understand, if we look at principles that were created back in England, Parkins versus Torvald in 1852, where an equitable remedies rectification in contract law, we begin to see the difficulty in putting our trust in a machine decision. Yes, for basic things, that's okay, but in a complex international award scenario, I find it very difficult that we will get there in 10 or 15 years.
Abby or Tom? Abby, see you've unmuted.
Yeah, look, I think we all have, pardon me, we all have the instinct that the more complex types of cases that we tend to deal with, it's hard to imagine that we would be comfortable with an algorithmic decision-making process. But let's just start by acknowledging that apparently there are online dispute resolution programs that are working for example, e-retailers. I think we've seen a fair amount written about that. Simple cases where perhaps the facts are not so much disputed, but here's, you plug in a certain set of facts. This is what occurred. What should be the rule that pops out? In those types of situations, I don't know if we would call that AI, but perhaps it is. That's already happening. So, the question is, how much more sophisticated can it become? I think there are obviously a great deal of reasons why it's very, very hard. Do we want algorithmic fact-finding, or do we want just algorithmic guidance on an assumed set of facts? What would be the legal rule? And most of the time, in the types of cases that we're dealing with, there is not an assumed set of facts. There's, fact-finding. Credibility assessment is a big part of what we do. One other idea just to throw out there, I've heard discussed. Maybe we wouldn't call it AI, but there is a great hunger for, at least for certain types of users, certain types of disputes, for a quick, fair resolution of disputes. There are circumstances in which there's crowdsourcing to decide a dispute. Again, not arbitration as we're classically referring to it, but there are mechanisms, technology-assisted mechanisms to resolve disputes, and perhaps we'll see more of that. Not for the type of typical large, complex case we have, but there may be more and more ways in which technology helps resolve disputes.
Tom?
Yeah, I mean, I largely agree with what Tunde and Abby are already saying, I think there is potentially, I think there probably is a role for AI to be a decision maker, to act as an arbitrator in these sort of, be it mass claims or repeated claims, relatively small amounts in dispute where there's really a premium on efficiency. Matters are relatively straightforward. The parties just, they bought a TV, it doesn't work, they want their $1,000 rebate back quickly, and they don't care if it's a computer making the call or not. I think as we increasingly move into complex cases where there's more at stake, there's less of a role, and it sort of goes back to what we were saying earlier. It's just more AI, not just in the legal industry, but beyond, plays a bigger role in these more mundane, repetitive types of scenarios, and less of a role when complex decision-making needs to happen. I think one of the reasons for this, and Tunde listed a lot of words, descriptive words with which I agree. I think it started with trust. To me, the big challenge is, I think of it in terms of credibility and transparency. If someone has a $20 million claim and they lose the case, they want to know why they lost the case. And the fact that a AI program, which is based on statistical probabilities and probabilistic inferences, said you had a 92% chance of losing your case, that's not satisfying. That doesn't have the level of credibility that users of arbitration in these more complex disputes need. They need reasons, they need explanation, and I think that's really where the limitations of AI as the decision maker start to come into play. Other considerations, Tunde's already mentioned these, empathy, ethics, professional responsibility issues, judgment calls. I think AI is going to struggle more in that regard, and that's why I don't think we're going to see AI robot arbitrators replacing human beings anytime soon.
Yeah, that's all interesting. Obviously, the evolution of the law. I mean, there are certain things that, the law does change, including judge or, a human-made law, and it's not just a function of where we've been that will decide where we're going. So I agree with everything that's been said about the limitations. I do wonder, though, whether or not it would be enough for someone, for example, and I think this is echoing what a lot of you have said, if there's a 92% chance that I'm going to lose, I just want to know that, right? Because I don't want to go through the expense of hiring a lawyer and going through a 2-year process, and if there's a 92% chance that I'm going to lose, I want to move on with my life and let's move on. But you're right. I mean, sometimes it's not 92%, sometimes it's 55%, and then what are you going to do? It's interesting. The 70% study that you I think a few of you have referenced, Supreme Court, I haven't read it, but just thinking about that and applying another study, which is analysis of X-rays. They compared, doctors analyzing certain X-rays and AI analyzing the same X-rays, and AI got it right in identifying a certain ailment more frequently than the doctors did. And so, part of you wonders, well, if you were only right 70% of the time, is it because the AI was wrong, or is it because the decision makers got it wrong? And so, you don't know where the bias necessarily is, because AI has bias, but so do the decision makers. Anything else anybody wants to say about? Well, let me move to the next topic, which is related, since we only have 10 minutes left, to what we've been discussing, which is, if not AI as an arbitrator or just deciding the entire dispute, are there certain elements of a dispute that AI can assist with? So, for example, assessing witness credibility just by hearing the tone of someone's voice. Is a machine how would that, and again, coming back to, I think, something that a few of you have said, arbitrators using AI as a tool to help them decide a dispute or some aspects of dispute, like discovery disputes. Do you see any role for AI in the decision-making process? And I think on this one, it was, if I'm not mistaken, Tom, that you had agreed to go first.
Yeah, I think the short answer here is yes. I think arbitrators can and probably should, especially as we move forward, use AI as a tool. And I think that's been a recurring theme over the last 80 minutes or so. AI is a tool that can be used by counsel, third-party funders, parties, and even arbitrators themselves. I think the big question, though, in my mind, is exactly how do they use that? And I ask the question how, more from a procedural perspective. If a tribunal wants to use an AI program to assess witness credibility, to look for relationships between data and the evidence, to help them on maybe some technical issues in a case, how do they go about that? Is it the tribunal that needs to drive that? Does the tribunal need to appoint an expert to assist them in doing that analysis? Does the tribunal leave it to the parties to come forward with the AI program and the parameters? I think there are a lot of questions in that regard as to exactly how it can be done. If there aren't the right procedural safeguards in place, and of course there's always the risk that the award might be challenged on those grounds. I'm not aware of any examples in the international arbitration context, but there was a case, I think, in Canada where a judge used an AI program to help determine what an individual's sentence should be for a criminal act, and the judgment was challenged on the basis that it used AI. And I don't think the challenge was successful, in large part because that judge relied on various other factors. So this was one of several sort of tools that judge used to determine the sentence. But I think I think the short answer is yes, it can be used as a tool by tribunals, but it won't always. It raises a lot of questions procedurally.
Yeah, I guess I would say, you know, it's interesting to consider that, you know, the impacts, let's say, of third-party funding on international arbitration. Third-party funders use to some degree various predictive tools to help make decisions about where they want to invest their money. And even if we weren't talking about third-party funders, but parties would want to make decisions about where they, you know, devote their time and energy and resources. And so if it were possible to know, I have a 90% chance or even a 70% chance of winning or losing, these, you know, people try to figure that out with technology or without technology. So if technology can help, or at least there's a perception that it can help, people are going to use it and are using it. Again, though, I would say that these types of predictive technologies are about identifying patterns, and the patterns mean that you have an assumed set of facts. And so I come back to the point that maybe for simple circumstances in which maybe the facts are not disputed or relatively easy to discern, maybe that's more useful. But so often in the types of cases I think most of us deal with, you don't know, there's not an assumed set of facts. Like, what even are the facts in the first place are what's disputed. And maybe, ironically, we would all agree what the result was if we could agree on what the assumed set of facts were. So I think that's, you know, it really remains very difficult. I mean, and to the example, I mean, I would just say it really is underscored by the example you gave, Rahim, of X-ray. I mean, there were facts that they're to be seen. You just had to look, you know, more effectively. There's no dispute about, you know, that's the picture. What do you see in it? But when you can't even agree on what's the right picture, that's when it's, I think, a lot harder.
Yeah, very well put. Tunde?
I think to a certain extent, we already seen the use of it in litigation, in the sense that certain aspects of robo-lawyers already use some sort of technology as analytics. And you have instances like Lex Machina from LexisNexis and Blue Jay from the tax courts. But to the extent that they will be used to assist the arbitrator in determining certain facts, it's going to be problematic. And I think of certain industries that where it just won't be possible. For example, in the maritime industry, where, and I'm talking about the wet kind, where the collisions happen at sea and where the facts are so complex, and you think, how can two VLCCs run into each other? Until you understand how ships work, and you can't program how ships work because no two collisions are alike. Even the arbitrators will have to have a fundamental understanding and experience that cannot be taught to any computer, that the use of that sort of algorithm would be limited in making ultimate decisions.
Well, thank you all. It's clear that AI is here, and its use is increasing as a tool. I think we all identified and agree that there are limitations to it, but it'll be interesting to see in 10 years from now, when Columbia Arbitration Day has this topic again, how folks will look back at this panel, if it's going to be on YouTube, and see how off we were, and maybe AI will be using we will be using AI to make decisions, or perhaps we all got it right. So I do want to take this opportunity to thank you all for your time. Really interesting conversation. I learned a lot, and I hope our audience did as well. Thanks all.
Thank you.
Thank you.
Mm-hmm.